I appreciate the opportunity to speak with you this afternoon. Let me just give you a little bit about my background so you understand where I'm coming from. I first was approached by the Indian government to talk about its nuclear liability regime in 2001 when the Department of Atomic Energy retained the dean of the Bangalore University Law School to do a study on the international nuclear liability regimes. And he went around the world meeting with various people, and when he came to Washington, no one in the U.S. government would talk to him because the sanctions were on in those days. But I sat down with him and spent some time talking to him about the United States nuclear liability law. Then in 2005, when President Bush first proposed reopening trade with India, we had a number of meetings to talk about that, and there were complaints from the U.S. government that U.S. industry wasn't doing enough to support the deal, and we told them that we couldn't really support it until India had an acceptable nuclear liability regime. And there was a meeting at the U.S. Chamber of Commerce where the Assistant Secretary of State for South Asia came to talk about the deal and to encourage American industry to get involved. And I raised the issue of nuclear liability. The next day, one of my clients got a call from the State Department saying that Omer Brown blew up our meeting yesterday. Does he know what he's talking about? And the client said, yes, as a matter of fact, he does. This is of great concern to us. So I'm not here to blow up your trade mission, but I do want to put the problem in perspective for you, because I remain concerned that the issue has not been solved, notwithstanding what we hear from the governments of India and the United States. In part of the deal that we had encouraged the U.S. government to come up with was for India, like the United States and soon Canada, to join the Convention on Supplementary Compensation for Nuclear Damage. And in September 2008, the Minister of Foreign Affairs of India sent a letter to the U.S. State Department saying that India would take all steps necessary to adhere to the CSC prior to the commencement of the international nuclear cooperation under the U.S.-India Agreement for Cooperation. As Colleen has said, one of the principles of not only the CSC but all of the other nuclear liability regimes is exclusive channeling of liability to the operator on a no-fault basis. And that applies in the CSC, the Paris Convention, and the Vienna Convention, and the laws of every other country with a nuclear power program. Unfortunately, the act that India adopted in 2010 is not consistent with these core principles. And since the Indian Act is not consistent, it may indicate why India, rather than taking a reservation to the treaty, is now trying to argue that its law really is consistent. Next slide, please. Since you're going to be getting copies of these slides at some point, I've reproduced the two sections. I'm not going to try to read them to you, but the problems are with Section 17B and 46 of the Indian Act compared with the parallel sections in the annex to the CSC. So at your leisure, you can look at the actual language and decide for yourself whether they go together. My conclusion is that they do not. Next slide, please. Earlier this year, there was a meeting between President Obama and Prime Minister Modi in India which has been characterized as a breakthrough on the nuclear liability problem. My view is that it was not a breakthrough, but really a breakup of the international standards. And on February the 8th, the Indian Ministry of External Affairs published on its website frequently asked questions and answers on civil liability and the Act, and I give you the citation to it so you can go and look at it. At the same time, there apparently was a memorandum issued by the Indian Ministry of Justice that has not been made public, but I am told is basically the same as what you see in the Q's and A's. And these appear to indicate that India plans to proceed to ratify the CSC based on this understanding between the U.S. and Indian governments that the 2000 Act really is compatible with the CSC. And media reports have indicated that the problems can be solved if and when the government of India submits its ratification papers to the International Atomic Energy Agency. And I was in Vienna last week and heard the Indian ambassador say that that this is expected to be done sometime in the next few months. And at that time, India would apparently indicate in its statement that there's an understanding of some sort that Section 17B, which allows recourse against suppliers, is to be read along with Section 17A, which is a standard provision in the treaties that says that if the parties agree, there can be recourse. The fact of the matter is that I don't know of any case anywhere in the world where suppliers have agreed to recourse in one of their nuclear liability contracts. So this is not something that would be standard practice anywhere. There also is a provision in Article 46 of the Act that appears to allow lawsuits under other laws than the nuclear liability law. And of course, this is also inconsistent with the principles of the conventions, which provide that you can only sue under the nuclear liability law, and that's why there is this channeling of liability, and everyone knows who's liable and for how much. Next slide, please. My view is that the frequently asked questions and answers and this understanding is based on the proposition that the two sections, 17B and 46, do not mean what they say on their face. And the question and answers make selective use of the legislative history to support its interpretations and conclusions that are, in fact, not consistent with the legislative history, because there are other sections in the legislative history where there was an attempt, for example, to combine Articles 17A and 17B that failed in the Parliament. But now we're told that that's really what happened, even though the Parliament rejected that. And at the same time, we're told that Article 46 is intended to apply only to the operator and not the suppliers, but in the legislative debates, there was confusion on the part of the parliamentarians as to what the provision really provided for. So in short, the legislative history, when you take it as a whole, calls into question the Ministry of External Affairs' current assertion that Article 46 applies only to the operator. And even if it did apply only to the operator, as I said, this would be inconsistent with the CSC because it would allow claims under other laws, which is inconsistent with a fundamental principle of the convention and the nuclear liability laws of every other country. Next slide, please. Now, even if India were to join the CSC, the CSC would not be binding on Indian citizens, because treaties ratified by India are not binding on Indian citizens without implementing legislation. And so a treaty by its own force does not become binding or part of the domestic law of India. So any memorandum of understanding or even this secret opinion of law would not be binding on Indian courts. So Indian courts, in my view, could be expected to enforce the two statutory provisions as they were written by Parliament, not as they were interpreted by the executive. Next slide, please. Now, India really has, under international law, an obligation to comply with the treaty if and when it ratifies it. The separate Vienna Convention on the Law of Treaties provides that you can't have a treaty that is inconsistent, or have domestic law that's inconsistent with the treaty you ratified. But that's what would happen here. and articles of the CSC itself require that there be consistency. And this implicates the general duty of each state to bring its domestic law into conformity with its obligations under international law, which would not be the case because of the difference between the CSC and the 2010 Act. So once India does ratify, and I hope it doesn't do it anytime soon without changing the law, it would be under an international obligation to comply with the CSC. But apparently that's not what is in the works. Next slide, please. The member states of the CSC have an opportunity, once India does ratify, to dispute whether the act would be in conformity. Now, apparently the United States has said it's not going to do that, but I think that is a mistake. The IAEA itself has taken a hands-off approach, saying they're only the depository of the convention. They don't take a position on whether a member state has a consistent law. So it really would be up to the other member states to do that. And unfortunately, acquiescing in India's joining the CSC could lead to potentially unlimited supplier liability, whether by operation of Article 46 or 17, which would contravene the most basic principles of the convention and the reason for establishing the CSC, the Paris Convention, and the Vienna Convention. Next slide, please. This also could lead to protracted litigation because of the complexity of the 2010 Act. For example, 17B would require a complicated determination that the nuclear incident resulted as a consequence of an act of a supplier or his employees, which includes the supply of material with patent or latent defects or substandard services. That could take years to litigate and at great expense to the defendants in the case, which in this case would be suppliers. And similarly, litigation under 46 could lead to protracted litigation. And the very purpose of these conventions and the channeling principle is to avoid protracted litigation and to make it easier for victims to recover. Next slide, please. Now, you may not be familiar with the way the CSC works, but basically parties to the CSC are required to maintain a domestic liability limit of not less than 300 million special drawing rights, which is about 420 million US dollars at the time. And if that's not enough, then the member states would be called upon to make contributions to the International Fund. The International Fund is based on a complicated formula tied to the number of a country's nuclear power plants and its United Nations share. For Canada, I think the figure would start out at around $50 million. In Canada, the decision has been made that operators would pay that amount, but unfortunately in the United States it would be suppliers that would pay. So what would happen if India joined and no Canadian or US supplier did any work in India, and India had an accident at a Russian-built nuclear power plant, Canada and US suppliers would get the bill. So it really doesn't make a lot of sense. Now, next slide, please. Now, India is talking about creating a nuclear insurance pool, and we're going to hear more about this. But it's my view that the insurance does not solve the problem because apart from departing from the core principles of the CSC, the pool would not be sufficient in itself, even when better developed and once the policies are disclosed. And none of that's happened yet. This pool hasn't really been formed. We don't know what the policies are going to say. We don't know what the coverage is, how much the coverage is going to be, or what the exclusions might be. Typically, the insurance pools are excluding coverage for claims after 10 years, even though India will now have a 20-year statute of limitations. The pools are concerned about providing for coverage for environmental damage and for acts of terrorism. So all of these things may be excluded. And normally, as we've heard, it's only the operators who are subject to the insurance. So next slide, please. So it's my view that supplier insurance is not the solution to the problem. In whatever amount or whatever provisions, it's not a substitute for the decades-long standards that have been established by the nuclear liability treaties. There's no precedent for suppliers maintaining duplicative insurance. It was a question about whether suppliers buy insurance. They don't. They never have, and it would only be in India where they would be required to. And then there are a litany of concerns about, even if this insurance were provided by the yet-to-be-formed Indian nuclear insurance pool with its yet-to-be-disclosed policy, it's likely that the suppliers would be exposed to liability for as much as 80 years. For example, if you supplied a pump in year 1 and the plant operates for 60 years and there's a 20-year statute of limitations, you'd have to maintain the insurance that you bought for 80 years. So you would supply a pump in year 1 and then you would pay insurance premiums for the next 80 years, assuming that the insurers would even continue the policy for that long. So it's not so simple to say that you can use insurance to solve the problem. And under Article 46, if indeed it does apply to suppliers, which it appears to, there is no limit on the liability, and you're not going to get insurers to provide you unlimited insurance coverage. So you could have an exposure without any monetary limit. Next slide, please. The one hope I have in all of this is that the Indian Supreme Court will end up finding the act unconstitutional. A petition was filed in 2011 seeking a determination that the act is unconstitutional. It's really based on the limitation of liability, not on other provisions of it. But that would give an opportunity for the Indian Parliament to revisit the situation. As it is now, they've painted themselves into a corner, and politically it's very difficult for them to get out of it. But this may provide a grounds for doing so. So, in conclusion, next slide, please. The so-called U.S.-Indian understanding is not the breakthrough that it's touted to be, but really an ill-advised breakup of the international standards that have governed the liability regimes for decades. India committed in 2008 to adhere to the CSC, but then it adopted a law that it knew was inconsistent. And I was involved in discussions with the Department of Atomic Energy before the act was introduced and warned them that what they were about to give to the Parliament would not be consistent, but it was introduced anyway, and once that happened, it was very difficult to make any changes. So all of this makes it a risky proposition indeed for Canadian, U.S., and other suppliers to do nuclear work in India until the 2010 Act is amended to comport with international standards, including those in the IAEA's CSC. And if a country can join the CSC without conforming its national law, it would seriously undercut the many years of efforts that all of us have made to achieve a more global nuclear liability regime, which is what's called for in the IAEA's 2011 Action Plan on Nuclear Safety, which was adopted following the Fukushima accident, and also with the Canadian Act that was amended just in February of this year. So it's really untenable to acquiesce in India joining the CSC without conforming its act, or to require suppliers to rely on some yet to be offered insurance policy. So that's quick overview. I'm sorry to be pessimistic about the situation, but I also think it's being realistic. And when you do go on your trade mission, I hope that you will deliver the message that India needs to improve this law and bring it in line with international standards. And there's also going to be a U.S. trade mission going in December, and I have been urging the participants in that trade mission to deliver the same message. So I guess we'll have some questions at the end, but if there's anything for
clarification. Well, I have one quick one. You said when do you think the Supreme Court might deliver the ruling?
Unfortunately, Indian courts are notoriously slow in acting. I mean, this thing has been pending already for 3 years with no further action. So it could happen tomorrow, or it could happen 5 years from now.
I have a question. I should really know the answer, but I don't. I work for Cameco, and as you all know, Cameco has signed a deal to deliver the first uranium to India at the same time as trade mission takes place. How do the uranium suppliers get around this?
They're not. Uranium suppliers? Did you say uranium suppliers? Well, uranium is a different situation. I mean, each company makes its own decision as to liability. Supplying uranium is a low-risk proposition. I mean, as I've said to some people this morning, I don't know of any case where Exxon was sued because the gasoline it supplied was what caused the automobile accident. So I think for a uranium supplier, it's a different risk. Small companies may have less of a concern because they have less to lose. Each company has to make its own determination. But for the major reactor vendors, this is a very serious problem.
Yeah, just about the uranium supply, I have been told by my ministry lately that liability does not arise for uranium supplies because they are converted.
Interesting how they differentiate.
Yes, sir.
Sorry. I wanted to ask a question about other laws that the supplier could be held liable. Can you give me an example of what other laws? Other than the CSC says that it's you, the operator, but then...
Well, it's the environmental laws, it's the product liability laws, it's God knows what.
Those are...
Yeah, any law other than the nuclear liability law. In every other country, if there's a nuclear incident, if nuclear material is involved, you can only sue under the law that governs nuclear incidents. Here, the Indian law says we have a provision for nuclear incidents, but then you can sue under any other law if you want to.
I just saw in the last bullet, untenable to acquiesce India joining the CSC, and you said earlier that the member states have sort of an opportunity at this point to object. And I was just wondering, if there is an objection, what source, where would that objection arise from? Is that like a responsibility of the federal government? And if so, have you? Well,
it would be the member state that would raise the objection at the IAEA with the other member states and just say that, I mean, there are provisions in the Vienna Convention law treaties that allow states to object when a...
Have you heard any rumblings of anybody planning to do so?
Unfortunately not. No, I mean, everyone seems to be afraid to do the obvious.
Okay, thank you very much.
Thank you.